Yes, today, interesting chat today. We do have back with us our special guest. You will remember Alan Robertshaw Esquire. Welcome back, Al. So we are chatting everything about this appeal, touching on the Australian perjury charges and what that might mean, and we might talk about how that may or may not affect the UK judgment, because whilst it's a long shot and a bit of a Hail Mary, we can always hope, can't we? So all about that, and all about everything else as well. And I'm just looking for my my chat window, because that's somewhat disappeared. Where's it gone? There it is. So I do see some super chats already. So I need to make sure we can bring those on screen properly. Let me Patty, let me bring yours on screen straight away so I can make sure we get it in the right place. I don't see any question or comment from you, Patty, but if it's just a by way of thanks, then thank you for joining us and watching us to discuss live here. We love doing these live streams. It brings us all together as a community. So so here we are. So we've been looking at this motion to set aside. I mean, where do you want to start, Al? Anywhere particular, or do you want to start with something more general before we deep dive into that?
It might be an idea just to explain what the procedure is, because I've seen there's a lot of confusion, even among some of the lawyers, as to what exactly the appeal procedure is and what's going on. And part of the problem is certain people may be doing things that aren't quite prescribed in the rules. But the situation is, at the end of a jury trial in Virginia, you have a right to say to the judge, I want you to set that aside, or I want you to adjust it, there's something wrong. And judges actually have that discretionary power. And this is something people were semi-relying on. You saw a lot of people saying, oh, well, what will happen on the 30th when the judge actually has to sign the order? Will she overrule the verdict? Will she change things? Now, the judge demonstrated how far she was willing to exercise that power, literally when the verdict came back, because she said, hang on, they've put $5 million in punitive, the cap is $350, I am going to change that now. And that was an exercise of her powers.
Yeah.
So, you know, she can do it at any stage before the final order is sealed. But what you can also do is then you can put in, before sealing, you can say, look, here's a series of things we think they got wrong, or things we'd like you to change. And you ask the judge that. Now, what happened was, normally these things are, like we described in another live stream, there's usually quite a lot of backwards and forwards comments. And you get that here as well, because you get an actual draft judgment sent to you to comment on. But the idea is you're just supposed to say, there's a few typos there, or can you just, we're not disagreeing with your decision, but could you just clarify that point or mention something about that? Or it might even be, okay, we see what your judgment is. We've had a chat with the other side about the back of that. We agree that there should be an injunction. We've agreed what the terms are. Can you stick that in the order? That's the sort of thing. So when they went along for the final sealing, and we know someone who was in court, and Elaine did try to sort of effectively run these arguments orally, and said, look, you know, this is why you should overturn the verdict. Now, there's a saying that judges sometimes use. Now, sometimes they use it legitimately, but it's if you want to argue that, put it in an application. Now, sometimes that is a legitimate thing where you'll be at a directions hearing and you'll say, I've got this great point. The judge will say, okay, well, look, put it in an application. So, you know, an application is you put a form in saying, we want you to do something, judge. Here's the evidence why. Here's the argument why. Here's,
yeah, and let's just pause there just so people don't get lost. So an application, I always say to people, whenever you go to court, and this goes for anything, this goes for a civil case, this goes for an appeal, it goes for a children matter where you're trying to decide who the children spend time with, when, how often, and so on, literally down to the phone number that they contact them on and all that sort of stuff. Whenever you go to court for any reason whatsoever, you're asking the court to make a decision. Why? And you're asking the court to make a decision because the parties can't decide. And that's a very generic principle across the board. I'm just going to turn my mic up, shout in the comments if it gets too loud, okay? Because I'm trying to get the volume just right. But let's try that. Yeah. Yeah, I see that, Alan, your audio is you're clearer today. That's because I've just turned you up. So hopefully we'll get the balance right. So when anyone goes to court, you're asking the court to make a decision. And that goes for any claim, any dispute, even criminal trials, all this sort of stuff, that you're asking the court to make a decision because the parties can't decide for themselves. And obviously in criminal trials, it's got to be done by the rules, and there's still a decision to be made. It's made by the jury. And in the US, civil trials are decided by the jury. So you're asking the court to make a decision. Some of the legal decisions, it's the judge that will make those. So the jury will never make a legal decision. The jury will only ever make findings of fact. And so we call that an application. In the US, some people call it an application, but it's usually a motion, a motion to do something, to admit something, prevent something, whichever. So each of those are a request. So yeah, just in case anyone was lost on that point, what an application is and what we're talking about, that's what it is. You go to court, you want the court to make a decision. So that I interrupted you, Al. So, but
no, that's fine, because actually, I was speaking in English terminology there, and what we call applications in the US they call motions. But sometimes a judge, when you're having a discussion, when you hear, if you want to argue that, put in an application, that is judge talk for, I've had enough now, just go away. Like, I'm not interested. You've not persuaded me. Stick it on paper if you want to have another go. And like I say, that's usually, you take that as, the judge has given a very straight, clear indication of their position on that. However, it does seem what happened was Team H went away and they put the same arguments that they'd made orally in a motion, and that has gone in. Now the judge is going to say, go away, I've finished, it's sealed. However, that gives us a clue as to what the grounds of appeal are going to be. Now, just to clarify, and again, there's some confusion over this about what is involved in appealing. Okay, and I'm just going to get boringly technical for a second about Virginia law. Mm-hmm. If you wish to appeal, you first of all have to pay what they call an appeal bond. Now, that's just $500. And that's the same for any case. So I want to appeal, here's my $500 fee to appeal. However, an appeal does not act as a stay. So the mere fact you're appealing something, the person who has the judgment against you can say, I want my money. I want my money. Now, if you say, well, I shouldn't have to give you the money until after the appeal, there's a conflict here. And the person who's entitled to the money is going to say, well, I'm not going to wait 2 years for that because you might have spent it all on lawyer's fees by then. Give it to me now. If you win the appeal, I'll give it back. Now, what the other person say, well, hang on a minute. If I give you the money and then I'm successful on appeal, you might have already spent it. So to protect both parties, if you want to stay, the person who the judgment is against has to pay the full amount of the judgment into court. And that goes into what we call an escrow account. And it stays there. And then once the appeal is decided, if the appellant wins, they get their money back. However, if they lose the appeal, they pass it on to the person who had the judgment in the first place. And that's why there's the interest thing. You have to add the 6% a year on, because they say, look, this person is waiting like another 2 years for something that they were entitled to from day one. So you have to pay them the interest. And that is called a suspension bond. So just when you see people talking about, oh, she's got to post this and she's got to put the full 10.3 up, yes, you would have to put the 10.3 million. And under Virginia law, you can't offset it against a judgment coming your way. You have to put the full amount in. You can't say, well, he owes me 2 million, so I'll just put the 8.3 in. That's not how it works. Mm-hmm. So that's what the position there is. Now, in Virginia, unlike here, you have a right to appeal as of right. You don't have to apply for leave to appeal. You instantly get in front of the 3 judges. However, those judges can dismiss the appeal on the face. They can say, we've had a look at this. You haven't got a leg to stand on. We're not going to entertain any further argument.
And just to pause there, on the face is a slang really for on the papers, and on the papers is the simple term for the judge or the judges literally take the documents and they have a look at it and they read it and then they send it back to you and say, no, we don't think this is going anywhere, so go away. And that's what we call on the papers, as opposed to everyone's turning up at court making oral submissions, oral arguments, live arguments to the judge, and with the right of reply and so on. So on the papers is literally the first look at it. And ordinarily, well, in England and Wales at least, ordinarily when something's decided on the papers, there's usually the right to renew that application to an oral hearing, but it's almost like you've lost it already. So it's a bit like your warning shot not to waste costs, because if you've been turned down on the papers already, you go back and have a sensible chat with the client and say, well, look, the judge has turned this down already. This is not likely to change just because we turn up and say, no, we really do want to do this in person. It's not likely to make a difference.
No. I mean, that's what I was going to say, because for our, England and Wales viewers, that's something that's quite handy, because a lot of the time, especially in the county court, you'll put in applications and the judge will make a decision just on the papers. And it might well be in your favour. But then you get the order out and it says, because this order was made without a hearing, if you do want a hearing, apply within 10 days. But like Dan says, it's very much, judges are very helpful at giving warning shots. I had a case recently where I applied for an injunction. And the thing came back listing with a note from the judge saying, having had a cursory glance at the papers, surely this is a decision that another body will make. And shouldn't the court just leave it to them? Because that's what it seems to me. And that was the judge basically. You'll lose. Do you want to withdraw the application and save some costs? And that was very, very helpful. Because it was like I could show it to the client and say, well, this is, as predicted, this is what the judge has said, and that saved everybody a lot of money.
And it also, I mean, in a roundabout way, there are some, I mean, this is trade secrets, I suppose, secrets, not secrets, I suppose, but there are little clues like this that we get from judges, which, the judge will often say to us, well, I'm minded to do this, but do you want to go and have a chat with your client first and then come back and decide whether we want to move forward with this? And then, you'll stand up, you're like, I'm grateful. Yes, we'll, take the adjournment for 15 minutes. You go out and you say, well, look, the judge is saying he or she's minded to do this. So you're better off either, accepting a halfway house or whichever. Because the judge has already said, I'm likely to go this way unless you can really persuade me otherwise, which is code for you're probably not going to persuade me unless you've got some killer argument that I don't yet know about, which is rare, really. I mean, but by the time you get to court, everyone should really know what's going on and what the arguments are and whether it's likely to go anywhere. Just while I've interrupted you, Al, we'll pause just on that moment while we've got Rachel's super chat here. Please talk about the UK judge conflicts of interest. Now, we did a long live stream about this, which is available to members. The full live streams go to members 24 hours after we finish it here. So we talked about it in a lot of detail, but just very, very briefly, I think our summary of that, Al, to be fair, is probably to say it will almost never happen. Should certainly never happen. We would never expect it to happen, but that's not to say it doesn't happen. There are possibilities of bias and conflicts of interest. It's not usually the case that, hang on a minute, this judge was at the chambers with, chambers is like an office or a firm or whatever you want to call it, but we call it a chambers. It's the sort of almost like a club, really, of barristers coming together. It wouldn't be right to say, hang on, that judge was at the chambers with this person and went to a dinner at the inns with the same person and, works with the wife of someone else, and therefore they're biased and there's a conflict of interest. We don't accept that as a default starting point. We don't accept that because it's a small world at the bar and the judiciary. So there's only 17 odd, I think, thousand barristers, practicing barristers at least, in England and Wales. Very small. It's less than half the size of my town here, and mine's a small town. So put it that way. It's like, less than half the size of a small town worth of barristers throughout England and Wales. And so we all kind of know each other. I mean, you won't know everybody, but you'll have come across most people in your area at least, and a significant number of others. So just to be in and around somebody doesn't mean that there's a conflict of interest. Just as, 1 week I might be representing a local authority and against a couple of individuals. The next month or whatever, I might be suing I know barristers that have to sue the bank with whom they bank and hold accounts. And there's no conflict of interest there. They're doing a job. They raise the claim for a client against the bank, even though they hold a bank account with them themselves. It's just that doesn't give rise to a conflict of interest. Now, I've deliberately not looked into all of these allegations of bias and links and this sort of stuff for two reasons. One, I think it's a bit of a waste of time because for all the reasons I've said, even if I chalk up 10 different reasons why you could say, all these connections must mean that they're biased. For one, I don't accept that. And two, it doesn't matter anyway. So that's why I've not done that. Unless you can add to that, Al, I think we direct the remainder of this discussion back to the live stream we did a couple of weeks ago.
The key issue here is, and I've gone through all the preliminary skirmishing in the UK case, and Depp's own legal team never even raised this as an issue. And the thing with a recusal application is you can't, unless some new information came to light, and it doesn't. Every like Dan says, everybody knows everybody. It's clear that Depp's team didn't have an issue with this. So the fact that they have not raised it. It's not, even if they wanted to raise it now, they wouldn't be able to. Yeah. But the fact is they didn't raise it, which seems to indicate they didn't have a problem with this particular judge.
It's a bit like, I don't know if you've seen it, Al. We've certainly not chatted about it. You've probably seen it. It's a bit like the argument about, I think, is it juror number 15 saying, no, hang on a minute, he's got, it's clearly he's born in a different year. Well, if he received, I believe from what I've read that he received the notice to serve on the jury and just turned up, even though it was intended for somebody else, and therefore whoever it was intended for had a different date of birth. But it's random anyway, so it doesn't make any blind difference whatsoever. So it's just as useless as saying, well, it was they were incorrectly marked as male instead of female. I mean, it makes no difference whatsoever. It's random. It's supposed to be an equal and representative mix of society, but if it isn't, well, it's random. It is what it is. They get their opportunity to object. They didn't. That's it. Tough. Move on.
Yeah. Well, especially the way, because over here, when we have jury trials, mainly in criminal cases, it's literally the first 12 out of the hat. Well, actually, what they do is they bring 14 people into court, and then they get them. They let the first 12 in. It's literally the only way you can object to them is literally something where you go, "Oh, hi, mum." It's got to be something that. They just literally, it's 14 people. Do you recognise any of them? No, first 12 sit in the box.
Yeah, or one of them's his accountant or something like that. It's just, there's got to be a direct link, which is so obvious that, hang on a minute. Oh, you're right, Fred, how you doing? It's got to be something like that.
We don't have any sort of questionnaires or anything like that. We don't know who the jury is until they literally walk in the courtroom. In the US, sorry.
No, so carry on. And we'll come to the super chat afterwards.
They have this voir dire procedure. We have something called voir dire as well, but that's a different thing.
And just pause, because I'm mindful that the terms will, with great respect to everybody, that the terms that we bounce back and forth as we would just chat, most people won't understand. Some people will, granted, because everyone's sort of learning whilst these trials are going on. A voir dire is a very old term for like a trial within a trial. So it's like a little dispute over the facts and a decision based on the facts, and they decide that before the main show, if you like. So, I'll give you an example. So if you've got, let's say you've got a defendant in a criminal trial who is saying, well, I'll plead guilty. And the judge says, on the full facts, and he says, well, I'm guilty if you say that, I turned up and I did this, but I didn't do that bit. I did this bit, but I didn't do that bit. But that bit, the second bit, is part of the main charge, right? And then the prosecution say, no, we don't accept that as a guilty plea. We say that the defendant did both of these things. Then you have this voir dire, trial within a trial, which is a mini trial on, what is the basis of this plea? And if the judge then makes the decision, well, it should be that's okay, excluding the second bit or whatever it might be. And then if that's the decision, then you come back into the main trial, and then the guilty pleas formally entered. that's what voir dire. So anyway, so back to where we were talking about.
Yeah, because our thing is, in like the US, they have those sidebars where they go up to the judge and all have a little whisper and sort of go,
And I'm picking up all your
here.
super chats as well, by the way. We will come to all your super chats. I'm favoriting them, and we'll come back to all of them. We got one of them on screen. We're coming to in a minute. From Okie Dokie, if that is your real name. We'll come to you in a minute. But I'm favoriting them, and I've got my dear wife also making sure we don't lose any of those. And what an opportune moment that would be to plug Easy Chinese Cooking. Everybody, this is my dear wife on Easy Chinese Cooking. Linked in most of probably every video that I've done. Please go over and subscribe for some excellent and healthy cooking. Anyway, sorry, where we are.
well, now I'm just hungry now, so that's where we are. But yeah, instead of having sidebars, we have voir dires, and they're a bit more complicated. We have to send the jury out when we do it, because it could be something about like the admissibility of some evidence or something like that. So judges aren't very keen on you doing voir dires just because of the disruption. But in this particular case, before the trial, each side gets a list of the prospective jurors and their basic details, and that would have included the date of birth. So they go, oh, here's all, and they can do the same thing. And do you know any of these people? Do you recognise any of these names? Are there any connections? Do we have any conflicts of interest? Then you turn up at the court, and their procedure for jury selection, it's almost like at school where you sort of, you pick one and then somebody picks one for a team. It's a little bit like that, where you each have a go of, I want that one, but then you've also got a certain number of objections. It's like, I want that one. Okay, I'm going to use one of my objections to say you can't have that one. But the thing is, at the voir dire, they see this juror, and they could have sort of said, "Well, hang on a second, no way are you 70." The chances are they never even looked at the date of birth, because I understand that this is something somebody alerted them afterwards and said, "There's an error on the form; they've got his wrong date of birth."
Yeah.
But the fact is, it clearly didn't mean anything to them.
And
they
it
just
doesn't
went,
make any difference whatsoever. So I'd probably stake my reputation on this being, just a bit of a nonsense argument that's just not going anywhere.
It's not going anywhere because, and I'm going to do my Mystic Meg thing. I know it's not going anywhere because there's a footnote in the grounds of appeal saying Miss Heard accepts that this isn't actually, it doesn't give rise to
I remember that. Yeah.
So that is weird. I mean, sometimes, we mentioned before about a big dilemma for barristers is, do you do what your client wants, or do you try and win the case? And they're not always the same thing.
Not always the same thing.
Because there were ways of possibly winning this case for Amber Heard, but you have to go with your client's instructions. This case could have been knocked out with probably 4 or 5 questions, just on a technical ground. But their instructions were, this is all true. Whereas if they'd have said, we're not saying it is true, but Mr. Depp, would you agree from your admitted behaviour where you did this, you did this, you did this? Somebody could reasonably and honestly think that did amount to abuse. So they'd probably have to say yes, and then that's the end of it because of the public figure thing and the actual malice thing. That would have just knocked it on the head. But their case was, it's all true. But sometimes you make an argument, and we have duties not to run arguments that are abuses of process. We can't do that. So we have to, and that's why they put that footnote in. It's like, we know this isn't a ground of appeal. We're just raising it.
Yeah, don't waste our time with that later on. Exactly.
Yeah, but sometimes you do arguments and you put in grounds of appeal, really to keep your client happy. So your client can read it and go, oh, you're really fighting my corner and you're saying this is all lies and you recognise it was a massive miscarriage of justice. But then you get to court and sort of go,
and
we're going to lose.
Sometimes that extends to the whole appeal. Like the whole appeal might just be, I've done appeals like that before. I mean, they have to be, as lawyers, we have to, the term is a properly arguable case. You can't just say, well, we don't like it, so we want to challenge it. There's got to be a reason to challenge it. I mean, it's not a very high bar. It can be, virtually anything, but there's got to be a properly arguable. It can't just be, we don't like it, so we want to challenge it. But I've been given instructions that I know. I've said to the client, look, this is a complete waste of time. It will not succeed. It's unambiguous, and it must fail, is the phrase that we sort of come to when we are sure about it. And your instructions are to go ahead and challenge it anyway. So ahead we go. Picking up Okie Dokie's, if that is your real name, your super chat here. Thank you for the super chat, by the way. But if denied, can they appeal to a higher court like criminal cases? Well, that really depends, doesn't it, Al? Because you can appeal again, so long as you've got reasons. But then if those reasons are decided, there's got to be yet a further reason that is wrong with the refusal.
Yeah, because this is like a state trial. So basically, it's all dealt with under state law. You've got your first instance case, which is the trial we've just had. You've got your automatic right of appeal to the Virginia Appeal Court. There is a Virginia Supreme Court. Well, there's a circuit Supreme Court. However, they're allowed to pick and choose what cases they select. It's a bit like here, where you can't automatically go to the House of Lords. The House of Lords will only accept a case from the Court of Appeal if it's on a matter of serious public importance, like, an issue that would affect millions of people. So if it's just a case of, well, we disagree with the appeal court because they ruled against us on this point, chances are the Supreme Court will say, we're not interested. If you'd have come out with some fantastic thing that will affect, all cases, great, but this is just something that affects somebody in one particular trial, so we're not going to entertain it. So this appeal, don't get me wrong, if they lose this appeal, I have no doubt they will make the application to the Supreme Court. But that will be pretty much the end of the line for them.
Yeah, and they'll still have to find a reason. It can't just be, well, we think the judge is wrong, so we want to appeal. They've got to hang their hat on something. There's got to be, again, they can't just waste the court's time for the sake of it. There has to be some arguable case. Eleanor, thank you for your super chat. I haven't read it yet, but is it okay for the judge in the UK to party with or have an affair with someone or be related to them, then rule over their case in court? Not in America. Well, to party with, let's take them in turn. To have a party with someone, I mean, what's a party, right? I mean, we've had Partygate in England and Wales. For those that are not familiar with that, the government made the rules not to have parties and get-togethers, and then people in government did it anyway. Is it okay? Well, look, if a judge is found at a dinner party with barristers with whom he's heard cases, then that's not really going anywhere. I would say if there's an affair or being related to them and then ruling over the case, that's almost certainly a case where they should be recusing themselves, because it's more than just going for a drink. It's more than just having a meal. It's going beyond that. It's going to a level where you have to look at it as the level of potential or prospective comparability of the judge, or anyone else for that matter that's within the case. I mean, it could arguably be an absurdity and an insult to justice to have someone prepared to lie because of their relationship with the judge, for example. So yeah, I mean, I think they're slightly different. I think that's sort of sums it up really, unless Al wants to add to that. But thank you for the super chat.
I think that's right. I mean, like we said, there's two stages. There's actual bias and appearance of bias. But I think something where somebody was in a very close relationship with one of the parties, or even one of the witnesses, that would be probably a grounds for recusal. But like I say, coming back to the UK, death and son case, that was something where there was a bit of a connection, but it's, like I say, it's something that nobody seemed to be bothered about. And the fact is that in the legal world and the media world, I mean, don't forget, we all used to hang around on Fleet Street together drinking in the same pubs. So lawyers and journalists do quite often have relationships, just even if they're just social ones. Because they're very similar professions. We work weird hours, and the entire industry is fueled by alcohol. So we have common.
And you can't go anywhere. It's like a small town. You can't go anywhere without seeing someone you know. It's just the way of it. And I've literally been in London one day in court with one barrister, and then up on the docket in Birmingham the next with the same barrister, and it's like, hello again. You can't make this up. It is such a small world. So yeah, you have to draw the line somewhere, and there's got to be a level of trust. And we're officers of the court. We've got full rights of audience. The minute you qualify and you're practicing as a barrister, you've got rights of audience up to the Supreme Court. So your word is trusted. And there's a very good reason that I mean, we went into more detail on this on the super chat, not super chat, on the live stream a couple of weeks ago, but we talked about the self-reporting requirement. So we are required, like if we do something wrong, we are required to ring up and say, yeah, I've done something wrong, you need to discipline me for it. And if you don't do that, then that's a different offence itself, for which you can be disciplined. And the same is true if you see someone else doing it, you have to report them, which is really not very nice. But again, if you see that and it comes to your attention and it's not clear that it's come to the attention of the regulator, but it is clear that you knew about it and you didn't report it, then you can be reported for that as well. And it's a minefield. So it's so self-regulated and very strenuously regulated. I think bar the very fringe of free speech, which is sort of quite topical at the moment. But that's where I suppose the line's drawn. But even then, you got to tread carefully. So yeah, it's not something that most people worry about. Matt Bond, if that is I think that probably is your real name. Thank you for your super chat. I'm in QLD. I put an FOI request for I think it's just a comment, isn't it? Yeah, I mean, I was having discussions, which I can't disclose, but I was having discussions about FOI, freedom of information requests. So public authority, public body has to respond and provide information that it has on an official request for that information. In fact, there's an interesting... one of the funniest FOIs I came across in my research for some video a couple of months ago was it's an offence to not assist a police officer in the execution of his duties. So if he's arresting someone and you walk by and say you're on your own, mate, and you don't help, that's an offence. But then somebody did a freedom of information request for how many people that have been prosecuted for that offence, and over the 4-year or whatever it was period that they looked at, they said 0. 0 people have been prosecuted for that offence. So I thought that was quite funny. But there we go.
So somebody down here did a freedom of information request on what speed limits are the local speed cameras set to, and they got a response. And now we're all going, great. So as long as I'm at 81 on this stretch of road,
yeah, you're all right. Yeah, fantastic. Jonathan McKinley, thank you for your super chat. Sorry, but how will the petition work if the Supreme Court said no? Well, first of all, it wasn't the Supreme Court that said no. Is there a number that it needs to make something happen? Don't fully understand. So, yeah, I mean, it's relatively straightforward in the sense that ordinarily Johnny's team would have to make an application to reopen the appeal. They won't, because they'll probably think that it's not worth the time, the effort, the money, the cost, the risk, and so on. So they probably won't. There's always, because the court can always do what it chooses to do, there is always the option for the court of its own motion to do exactly the same thing. And it usually comes from the top down, Lord Chief Justice downwards. And that is always an option. It's a very rare thing. To be frank about it, it's ordinarily highly unlikely. But I would suggest this is the paradigm case that if that was ever in history going to happen, it's now, because this is just unprecedented with the comparison of the UK judgment and the Virginia verdict, given that Amber wasn't the defendant in the UK, even though Elaine's going around saying Amber won in the UK. She didn't win in the UK. This I suggest is the paradigm case for that. So I think it would need, is there a number that it needs? Well, who knows? It needs enough people to make someone in the office think, hang on a minute, there are a lot of people here that want this to be looked at. We should look at it. But I think it's going to be significantly north of where it is now, to be quite honest. I think it's going to need upwards of 1 million signatures, quite frankly. I don't know what you think, Al, but if I were to venture a guess, I would say at the very least 500,000 signatures to put weight behind the petition to say this has got to change because it makes the UK look bad. Because let's face it, it does. A lot of people think this decision makes the UK look bad, and that's not even my opinion. It's the opinion that a lot of people have given to me. I mean, I think everyone knows my opinion, but there we go. Any venture as a guess on a number, Al? I would say at least 500,000, but I don't know what you think.
I would have thought so, just to get the public momentum. I mean, one thing that might assist is a lot will depend on what happens with the appeal in the US, what happens with any cases against Amber Heard in other countries. I mean, I think if she got a perjury conviction, then that might... Yeah, because also you've got to remember that there's the PR element here.
Yeah, if we can just pause there, Al. That's exactly what I talked about on Popcorn Planet, which the video dropped, I think, about half an hour ago, 45 minutes ago. That is linked in the description. Don't leave this live stream to watch it. Bookmark it, and you can watch it afterwards. But I'm on with Andy Signor on Popcorn Planet. I did tell him I would be plugging that video here because I knew that very point would come up. And to reiterate it, Al just said it could well make a big difference if the perjury charges stick in Australia, even if they don't insist that she's extradited and and stand trial for it and so on and so forth. But even if they say no, we think she's guilty of it, I think it would make a significant difference.
There is because one way of getting around all the difficulties of second appeals is that there's a saying in the law: fraud vitiates everything. And if you can go after a case has been settled and decided and it's gone through all the appeal courts and you finish it, then you find some information that wasn't readily available at the time, exercising reasonable due diligence to support the test. You can say, look, actually, we understand it was the end of the line, but everything was based on a lie. Yeah. Everything was based. But the trouble is, that's usually, claims. It does not necessarily, though. It could be, look, this was a completely fraudulent defence and we can prove it. It's always going to be difficult in a case like this, though, because it's not really going to the substantive facts. It's going to the credibility of somebody. And the trouble is, appeal courts very much leave issues of credibility to the trial judge or the jury. They say, we weren't there, we didn't see what was going on, we didn't see how people reacted. You can never get the flavour of it from a transcript unless there's anything substantially wrong on the record, like that we can sort of go, actually, just reading that, there might be some intemperate language from the judge or something like that. It's very hard to interfere. But this appeal, one thing, to divert a bit, the application for leave to appeal in the UK court case shows the importance of putting your case. And you remember we've spoken before about if you wish to challenge something, you have to put it to that witness and give them an opportunity to say yes or no. You are a liar, aren't you? They're probably going to say no, but you have to put that to them. You can't sort of not suggest a liar and then say to a jury they're lying. Now, what's interesting is because we've got this donation point, and in the leave to appeal application, one of the reasons they knocked it back and said, we now have documentary evidence that shows there was no donation, that she didn't donate the money. And we'd like to put that in now. But if you want to put in new evidence in an appeal, there's a test called the Ladden-Marshall test because of a case involving somebody called Ladden and somebody called Marshall. And there's a 3-part test. And it's all, the evidence mustn't have been available originally, either not physically available or you couldn't have found it with due diligence.
With reasonable diligence, Yeah,
has to be relevant to an issue in the trial and might have made a difference. And also, on the face of it, has to be credible. Now, the fact is, they could probably prove points 1 and 2. Look, we didn't know about this. We tried for this with a third-party disclosure, and you knocked us back. So that's, you can't say we didn't exercise due diligence when you're the one who said we couldn't, have this. There's nothing to suggest it's not true because it's the ACLU's own records. However, the test said, yeah, but it's got to be relevant to an issue in the trial. And that was never an issue in the trial because you chose not to put to Miss Heard that she hadn't made the donations. And they hadn't. And when it was analysed, it turns out that, because they said, well, look, Mr. Depp, on his own evidence, is saying, from day one, I know she didn't pay this money because I was paying it. And I know she didn't pay it. So I said, you were on knowledge. Your case was, you knew, or your instructions were, she hadn't paid this money. And they said, well, we didn't bother putting it to her because we didn't have the rebuttal evidence. So they go, well, that's not the point,
Yeah, and let's pause there because I was thinking about this today about actually doing a video for it because the point, I mean, a lot of people, actually, I saw a comment and someone said, well, why didn't they put that then? Because this was one of the points that I think it fell down for on the permission to appeal. Now, this is, I'll make absolutely clear at this point, this is not a criticism of the lawyer, and I'll explain why. Well, Al's just said why, but we're going to explain it so it's absolutely clear. Because they didn't have the sufficient evidence to say that it hadn't happened. So there's no point putting it to her because they didn't have the evidence to back that up. It's a bit like me saying it's raining outside, but you can't look outside. You know, you're not allowed to go and look outside, but I'm telling you it's raining. Do you take my word for it? Or, you know, or if I'm putting that to a witness, or let's say I'm telling a witness that I've got a UFO in the garden. I say, you know, I've got a UFO in the garden. You can't look at it, but, you know, I'm just telling you that it's there. It just doesn't really mean anything. So unless you've got the evidence there. So that's why they didn't bother putting it to her. But then obviously when it came to the permission to appeal, the appeal court said, you know, well, you didn't put that to her. So it doesn't really matter whether, I mean, it's absurd because this is where we've discussed before that the procedure and the rules and the law and everything else is not necessarily in line with what people think of as justice. And I know that sounds awful, but it's true. Because let's say I know I'm going on a tangent, but I think it'll prove the point. But if you don't engage with a claim against you at all, you just ignore it, then you get judgment against you. You could be absolutely right. The claim could be totally bogus. But if you don't respond to it, you get judgment against you. That's not justice, is it? Because you weren't wrong if it was a bogus claim. But that's the point. You have to follow the rules and you have to go along with the rules. So you've got no choice but to participate. And you either do that yourself or you pay lawyers to do it. And here, you're going to pay the lawyers first and then wait till what we call the final resolution of the issues, which is a fancy way of saying right at the end of the trial, which is probably 2.5 years from now, when you've paid all your lawyers up front, then you might get your cost back. But as long as they've got the money to pay you those costs, which they usually haven't, right? So the last frivolous claim we dealt with against us, they still owe us about £10,000 in the costs because it was a totally sham claim, which got, actually, funnily enough, as we said earlier, it got kicked out on the papers, and they came back and said, no, we really do want this claim to be heard. And the judge brought everyone in and said, no, well, I still don't agree with you, so get out. And then they tried to appeal it. Then the appeal judge said, no, I don't agree with you on the papers. And then they came back again for an oral hearing, said, no, I really don't agree with you. So this was like over 5 or 6 years or something. And, £10,000 because we fairly lean on the costs. I mean, £10,000 is not a lot of money really to spend to defend a claim. Believe me, it's normally hundreds of thousands, but we'll unlikely to ever see it. That's the justice of it, or injustice of it, as the case might be. So, I'm not speaking out of turn because this is absolutely true, every word of it true. I would tell you if I'm speaking out.
No, I'm just thinking of something ironic here because, like I said, I do a lot of defamation work, mainly defence side. But I did a case for somebody where it was bringing a defamation claim, and the person didn't pay me, and so I go, what was the claim? Oh, it was saying that basically he'd been defamed because somebody had said that he never pays his bills. And they're going, and you did that case on credit. It's like, I know, but it just seems so nice to him. Yeah. I mean, I'm sure it's all a misunderstanding.
Yeah, it's just like you get. I mean, we don't do many criminal trials, but it's like when you get a criminal charge client coming in saying, I'm being accused of fraud with handling cash that's proceeds of crime and all this sort of stuff. Can you help me? Yeah. How are you able to pay? Only in cash.
Yeah. I've got this hold all.
Yeah, I've got a bag of cash here. But I mean, funnily enough, for that very reason, it's a specific defence under the Proceeds of Crime Act. If you render services to the value of the money that you're given, it's a specific defence to handling money that is proceeds of crime if you've performed services in return for that cash, if that makes sense. So it's there for that very good reason. Kate, thank you kindly for the super chat. I'm sure did I do my video on? I think I've done a video on this, and it's certainly what we talked about on Andy Signor's channel. I'll put my video linked in the description as well. In a nutshell, yes, Australia has confirmed that they are looking into what happened here. I did a fuller video on this, but in a nutshell, what happened was in 2015, she was taking dogs to Australia. Didn't have the relevant paperwork. They weren't cleared for quarantine. It was obviously found out. She asked Kevin Murphy, this is all in the UK documents, she asked Kevin Murphy to make a false statement, asked him to ask Kate James to make a false statement to say that they had this stuff. She apparently, according to Kevin Murphy, told the Australian authorities that he said it was fine to bring them in. And then she pleaded guilty in 2016, I think it was, to say, I didn't have the right paperwork. It was just a bit of a mix-up. But yes, I'm guilty of it. But it was more a mix-up on the papers than it was being dishonest. But of course, when this case in the UK came to light and all the witness statements came forward, including Kevin Murphy's, which I can probably find actually, it's paragraphs 7 and 9. Al's very much like me. We get very nerdy with this stuff. We know exactly where it is in the documents. So I'm opening the document. It's paragraphs 7 and 9, which are of particular interest. So switch to me, Al, and preview. Paragraph 7. This is Kevin Murphy's witness statement in the UK trial. Amber was subject to criminal proceedings in Australia for illegally smuggling the dogs into the country, yada-da-da-da. I told Miss Heard I was uncomfortable with giving a false statement to the court and that I would not ask Miss James to do so. And then paragraph 9, the end portion of it, this is how nerdy we are. I understand that Amber later told the court in Australia that I told her that it was fine to bring the dogs into Australia. That is false. I never told her this. That bit there is why Australia is now looking into perjury charges against her, because Kevin Murphy's effectively said she lied. She said that I said it was okay to bring them into Australia. He says, and it's these words here, that's false. I never told her this. So those few words are why Australia is looking into it. Because if she lied in her pleading guilty, it's like what we said about the voir dire earlier, about if you're pleading guilty, on what basis of facts, and is it accepted? So if it was accepted back then, they say, okay, fair enough, you got the paperwork wrong, yeah, we'll accept that, bit of a fine or whatever it was, I can't remember now, then that'd be that. If it later transpires, like Al said, like the phrase fraud vitiates everything, vitiates, nullifying, contradicting, turning over, making dead, making wrong. Again, it's just another phrase, but fraud makes wrong what you've done before. It's a bit like you can't have a fraudulent contract, and when they don't pay you, go to court and sue them over not paying you if it was fraud in the first place. It doesn't make sense, and so you can't do it. So this is what the Australia thing is all about, because Australia is saying, hang on a minute, Kevin Murphy says you lied to us, and that's it. Unless you got anything to add to that, Al?
Well, people keep talking about perjury, but this goes beyond perjury. If the allegations are correct, this is conspiracy to pervert the course of justice, which is
absolutely, yeah. And again, there's a difference between the two. So what we like to do here for you guys is to not just like throw these around, but to explain them as well. Perjury is lying under oath to, on an official statement to someone in authority. If it's to your friend, then it's a misrepresentation. It's you were just false. You lied to them. If it's to an authority under oath for something serious and something official, it's perjury. But perverting the course of justice is doing anything in the process to with the aim, the intention, or even the risk or the recklessness of having an unjust outcome where an authority makes the wrong decision. And it's a bit like if you try to take a fine for someone else or a penalty for someone else, or in the UK we have penalty points on our driving license. The common thing, shockingly common, as I've recently been quoted in the press for saying, is that a spouse will take points for each other so that they don't rack up too many to get banned from driving. That's perverting the course of justice. And that's a very serious offence. Sorry, Al, I interrupted you, but I wanted to make that clear.
That was just it. It's just like I said, the people keep focusing on the perjury aspect, but this goes beyond that. Because just you lying on an official form, that is very, very bad, obviously. I've signed, because you sign it saying it's a declaration of truth and this is true and I'll go to prison if I, aren't telling the truth. That is one thing, but what courts don't like is dragging other people into your attempts and sort of saying and this does happen. I mean, things that pervert the course of justice, like washing somebody's blood-stained socks, something like that. That's actually something that crops up quite a lot, where, getting rid of evidence for somebody else. But a very common thing is, can you make a false statement for me? Can you say I was playing pool with you that time? Can you take the points for me? But basically saying, effectively, can you just lie for me and take the hit for me? I mean, it's the equivalent of doing can you take the points for me? It's like, I want to blame my assistant and he's going to take the hit. But, forcing somebody else to commit perjury on your behalf crosses the line of perjury and goes into conspiracy to pervert the course of justice. And that,
exactly.
Again, if she was to be charged, it wouldn't surprise me if that was the charge rather than a straight perjury charge.
Yeah, rather than just perjury, yeah. And Matt makes a good point. They weren't vaccinated, so... of course, cross-territory transport of animals is as serious as it gets. I've got an ant farm in the corner over there next to my YouTube plaque there somewhere. It's mirror image, so it's hard to point there. It's a Japanese ant colony, so it would be a criminal offence for me to release those into the garden because it would just totally upset the landscape here, because they potentially be very aggressive and take out fields worth of native ants, but who knows. So yeah, it's a good point, Matt, and thank you for the super chat. I appreciate that. And Georgine, welcome from the Philippines, and thank you for watching. Yes, I know, Al, I agree with you. I think it much more likely be perverting the course of justice rather than just straight up perjury. I'm just looking. I'm scanning through Kevin Murphy witness statements. See if there's anything else of interest in here, but I don't think there is. But oops, no, I don't want to ban anybody. Right. So we've now also got. I don't know if you want to move now with the sort of very not so brief introduction to all of that. The motion itself. I don't know if I can make this. Let me try and make this bigger. I've got to unlock it and then try and make it bigger. Swoop. There we go. And now I'm going to lock it again so I don't keep moving it. So yeah, so we've got this. This is the motion itself, and
which minor gripe, but it's not put on the proper template you're supposed to use. So there are no line numbers next to it, which makes it really hard to navigate. Because Americans, over here, we have a format where we just number each point by paragraph. So I can say, well, I refer you to paragraph 17 in my skeleton argument, or I deny paragraph 400 in the particular claim. In the US, they use special paper they're supposed to do that's got like line numbers down the side of it.
Yeah, it's a line on the side, yeah.
And they didn't do it on this one, and it's really annoying, which makes me think they typed this rather quickly.
Yeah, that's a very good point, actually. I'm just looking to see if I can find an example of one that is properly numbered. In fact, most of them actually aren't, which is actually quite annoying. But yeah, even this one is just normal paragraph numbers that I'm looking at now. But anyway, you take the point. But
I think I can do this with the magic of technology. which I'm not very good at, as anybody who ever sees me try to use technology will acknowledge, I am going to, if I do this, and I hope this works, and I do this, and then I put this there, and then click that, Dan, in your messaging thing, you should have the standard, and it's not like it's difficult. You can get this as like a Word template. So this is what you're supposed to. This is how you're supposed to do American filings.
Yeah. So let me just open up that. So now I can, with equal technological wizardry, I can open this and zoom in. So yeah, you can see now the numbers down the side. So it's like a template paper essentially. So literally every line on the page is numbered. And so if you wanted to refer to, the defendant's name or whatever, you just say in, line 9. I don't know if you can see that very clearly on there, but anyway, yeah, they're all numbered there like that.
I mean, they've laid it out correctly, but they just haven't used the line numbers, which is, like I say, I suspect a judge would get very... Over here, just to say, there are very strict rules about what we have to do in terms of what font we use and what spacing we use. And the QBD, the Queen's Bench Division Court Office in London, has been rejecting paperwork because it's not been in the right font. And that has resulted in cases being struck out. We're talking multi-million-pound cases. And then people go along and said, can I have relief from sanctions? I'll do it in the correct font this time. And the judges have said, no, the practice direction is really clear. So people have lost out. People are facing multi-million-pound negligence claims because they used the wrong
font.
Yes, so be very aware of not annoying courts by putting in things that aren't in the proper form or that they can't read.
Yeah, what they have done is they've got like a table of contents, and then they've got the sections laid out. So all the authorities, as you'd expect. I mean, just it's a horrendous list of authorities. I mean, most of them are probably only the tiniest, minuscule reference of something. But you've got the summary of the argument here. So. Yeah, we all know what the summary of what he was trying to do is. I'm not going to use certain words because YouTube will start limiting the video and not sending it out to people. But yeah, I mean, a lot of the... I mean, I was reminded of the opinion letter the court wrote when they tried to kick this out in the first place, having been heard in the UK. And the court was like, well, no, because the op-ed wasn't even published then. So how could he have had this grievance heard already when this wasn't even published? So they're talking about the op-ed, obviously, which is why I bring that up. The jury's verdict was obviously influenced by Mr. Depp's pleas in the face of the court's preclusion of me. So this, my overall interpretation of this, Al, you probably give some further thoughts. My overall interpretation, it was just very long-winded and sort of more verbose than actual hard argument. Yeah,
there's I mean, I can go through the points very briefly. Like I say, I think this is written to keep this is written to keep your client happy. However, there is one potentially good point, actually, which not only... I mean, basically, just to explain generally what you can appeal on, as we've said lots of times, you can only appeal on errors of law. You can't generally appeal against findings of fact. And it doesn't matter if the appeal court goes, actually, I would have found a different finding of fact. I wouldn't have believed that person, or I would have believed that person, or I would have found on the evidence that it was more likely this happened than that happened, which is not what the trial judge found. But so long as it's within a range of reasonable, it's a reasonable inference you can take from the evidence, they won't interfere with that. You can only really overturn findings of fact where it's something like there's no evidence to support it. So say, for instance, there's a trial where there are 5 witnesses and it's about what colour a car was. 3 witnesses say, I don't know what colour the car was. 2 witnesses say the car was blue. And the judge says, I found the car was red. You say, well, nobody even argued that, so that cannot be a finding. But these are very, very rare. And a lot of the motion is basically saying, we think the jury were wrong to believe this. The jury shouldn't have believed this person. The jury shouldn't have drawn that inference. The jury shouldn't have, basically, it's literally, we disagree with the jury's assessment of the witnesses and the evidence. That can never, ever form a ground of appeal. You have to identify an error of law. and they've gone for a few. I mean, like I say, some of the ones they're trying, and what's interesting, there are some that they've tried to couch as errors of law, where they're saying, oh, well, in order to find for the claimant, because he's a public figure, they would have had to have found that this was done with actual malice. And they're going, well, there was. They tick this. There's literally a box on the jury form where they tick it. And, this was all put, and they're saying, oh, it was never suggested that, I mean, it's weird. In some ways, it's like it was written by somebody who hadn't seen the trial. I'm not being facetious there. There are references in there to things that demonstrably did occur. They're saying this was never put to a witness, and it's like it was. This issue was never raised. Yes, it was. There were about 3 days of rowing about that. We all saw it. So that is going to be very difficult. Their technical grounds are quite interesting. They are running they are first of all running the jury verdicts were inconsistent. And again, it's like, were you at the trial? Because they're saying Mr. Depp won because they're saying this was all false allegations. However, Miss Heard won, and her counterclaim was that you accused me of this being a hoax. So if you found for me on that, these are inconsistent verdicts. And sometimes an inconsistent verdict can really help you if it's logically inconsistent. No way can these two facts be reconciled. But the fact is, there were Amber Heard's counterclaim was split up into 3 separate, counts, as we're calling them incorrectly. 2 were just general, this is a hoax. 1 was specifically a very complicated one about, they rigged the penthouse scene and they called the police and then she did this and then she did that. That's the one they found against, but they didn't find for her with it's a hoax, which of course is completely consistent with their claim. Their claim is this isn't true, it's all a hoax. And that she lost on those points. So it's not an inconsistent verdict. And it's weird because they don't even address in the motion the fact that there were 3 separate counts there. And again, it's almost like somebody who hadn't seen the trial wrote this. So that is going nowhere. The other ground they're arguing is that the UK judgment should have gone in, because not just as evidence that JD had done certain things. They're saying the UK judgment there's no need to have a trial. We should never have allowed a trial because it's already been dealt with. The trouble is, the Virginia statute says that only applies when there has been a previous trial on the same issue, quotes, between the parties. And it literally says that. Now, one thing appeal courts rarely do is go behind the plain words of a statute. They go, it says between the parties. There's no room for interpretation there.
This is what it says. Yeah.
But they are trying. I noticed that they're trying this phrase that came out before Elaine sort of her media career was curtailed for whatever reason. He was saying a lot about Amber Heard being the effective party.
Opponent, yeah.
And they have put in an argument saying, in I think it's Florida, they do actually allow an effective party interpretation. But, that's a different state's laws. And the courts will say, well, that's great, go to Florida and argue that.
Yeah.
The trouble they have there is, even if the court accepted that and said, okay, we accept that, this might have been brought by one party, but effectively it was this. I mean, you might get this sometimes where it's like a claim was brought on behalf of a company, but it's really about one of the directors, something nerdy and technical like that. But the problem they have with that is on the facts, when in the UK case, when Depp's team said, we want third-party disclosure against Miss Amber Heard, it was refused because Amber Heard said, I am not a party to this case. I'm a mere witness. I don't have a dog in this fight, which is an interesting argument. I am a witness. I am not a party. I have no interest in the outcome of this case whatsoever. Which is, and basically, the third-party disclosure application failed because they said this person is not a party to the case. And I think the Virginia Court of Appeal will say, well, hang on, you cannot in the same set of proceedings you're seeking to rely on say, I was not a party in this case. However, I would like you to say I was a party in this case, so this trial can't go ahead.
Well, I did a whole video on this because it really irked me, because I think either in the thumbnail or the title, I said, you can't have it both ways. And this was the bit that I referred to, because as Al just said, if, again, I'm not being disrespectful, but if this escaped anybody, so Amber was not a party at all to the trial in the UK. She was a third party, and she was a non-party third party, which I I even had to explain in the video. You can be a third party to the litigation, so you can have the claimant, the defendant, and a third party as a named party within the claim, and so you've got a real standing and something to do. So if I drag a bank in because they've got the defendant's money or something, then they are a party to the litigation. If they're just a third party, like in the normal, ordinary, natural meaning of the word, like someone else, then they're not a party to the litigation. So they are not subject to all the same rules of disclosure, which are verbose. There's lots of different rules, and they're fairly stringent. Anything that could reasonably undermine your own case or assist your opponent's case, you have to disclose, but only if you're a party. And she was not a party in the UK. You can see that from the top here. Again, we have like a tramline heading here. These were the parties: claimant and defendants. Johnny Depp, the newspaper, and the editor. And so here the judge addressed this. Now, coming back to the current Virginia appeal argument was, well, she was really the effective opponent, so it was kind of already heard in the UK, so it shouldn't have been heard here in the first place. Like, no. You can't have it both ways. They argued in the UK that she shouldn't be, subject to the disclosure obligations, and here, again, judge's own words. The judge. I don't agree with them, with all respect, but again, like you say, you can't have it both ways. I'm not persuaded that these comments carry any weight, and I'm thinking, well, why not? Because all of this was about her. Okay, the newspaper published the article that the editor wrote, but it's all about her. So how can you test what happened with her unless she's actually party to the litigation? Because you're never going to get all of the information. And I would bet there's a significant portion of it did not ever make its way into the trial, even the Virginia trial. But at least she was a party to the Virginia trial. But anyway, the point was this: the judge here ruled that didn't carry any weight, so she didn't have those obligations. So it doesn't carry weight in this the Virginia.
They'd raised this point before the Virginia trial to say the Virginia trial shouldn't go ahead, and the judge gave a very clear ruling that I think it would be very hard, looking with a legal head on, it would be very hard to argue that she misinterpreted the law there. Because like I say, it is very, very clear that it just says between the parties. And that's why, when people say, oh, the judge said Johnny Depp didn't get a fair trial in the UK. That's not quite what she said. She said that did not represent a fair opportunity for him to raise the issues he is now raising. So she wasn't saying the trial was unfair. She's saying that trial might have been perfectly fair for the issues that were at hand in that case. However, this case is about different parties and different issues.
Yeah,
so
and exactly.
The UK trial is irrelevant.
And we've discussed this. I don't know if it was on air or off air, but we've certainly discussed this to the effect that, in one sense, the judge in the UK trial, on the basis of the facts that was before the court then, and for some quirks of circumstance, perhaps, of the way rulings went, that judgment was, at the time, was probably all right, based on everything before the court then. It's the appeal that I've got a problem with, because when you look at the arguments, they're fairly compelling arguments, and particularly now, with the Virginia trial now uncovering conclusively that she hadn't paid this donation, that it was all based on in the jury's eyes, it was based on lies. It should have an effect on the UK trial or the UK appeal, and particularly now with the Australian thing, it's just even more. I'm just looking for it. The court did an opinion letter, which I'm just looking for. They never name these documents with a full name, which really irritates me.
Well, that's the joke we were saying about just how documents in emails are now, where it's always something like definitely final draft version 2.0. Honest, this is the last one. Oh no, wait, hang on, ignore that one. This is definitely the final draft. ...
Mark 3.
Yeah. Just to say about actually, I know your view is like little legal trivia.
Yeah.
When we amend documents officially, like pleadings, it's really strange now because now we do them all online. But it used to be that if you added something, you did a different colour, and there were 8 different colours to show which were amendments, re-amendments, 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 and they had 8 colours. Because I think the idea was if you haven't got it right by the 8th attempt, we're just giving up here. Yeah, but there is a list of which colours you're supposed to underline in. And the weird thing is you're supposed to underline the underlinings. And if you ever see and this happens a lot in defamation because we have preliminary hearings to sort of settle issues. So you'll put your claim in and your defence in. Then you'll have a hearing about what we call meaning and any defences. And that quite often ends up with bits of the claim being struck out and then bits of the defence have to be amended. And defamation paperwork, by the time you get to trial, is just like, it looks like something you would stick on the fridge because your 4-year-old did a really nice job with it. But having said that, most courts now say, well, actually, the pleadings are just to get things kicking off. And once you've got to the stage of statements and evidence, we can pretty much put the pleadings to one side because, I can just do it on the statements.
So this is where this is within the rules. Where colour is used, the text deleted should be struck through in colour and any text replacing inserted underlined in the same colour. The order of colours to be used for successive amendments are red, green, violet and yellow.
But there's 4 more. It's like croquet ball. There are 4 secret other colours that you
These are just the first ones they came up with. So these are the priority.
Yeah. But like I say, it's quite interesting. So if you ever see, like I say, especially in the old days where you had to just type them out and do it with the ruler, they got incredibly messy.
So this was the I found it now, the opinion letter from the court on the motion for plea and bar. Bar being stop, stop right now. You're not going any further. And so the court did a full opinion really on this. Collateral estoppel, much the same. We've done it before. We're not doing it again. Privity, essentially, the party might as well be the same party, and court ultimately said no, it's not the same party because the Sun published the article. They would have doubtless relied on what they were told. So in a roundabout way again, they relied on whether it was true or not. And funnily enough, I mean, there's a spur here. I mean, there's a potential offshoot of litigation for the Sun if Amber is found to have lied and all the rest of it. For the Sun to say, hang on a minute, you lied to us and put us through all this rubbish, right? Potentially. And then res judicata is similar to, we've done this before, let's not do it again, but more on the basis that it's unfair to do it again, a bit like double jeopardy. It's a very, very chilling effect. This was an interesting point. It was essentially, it would be a chilling effect to redo things in the US when they've been done in the UK. And again, the court said, well, no, because it's not the same thing. It wasn't the same thing in the UK. So no, we don't agree. And the bottom line is, out of all those pages, the court said no, we don't agree. So the trial's going ahead, essentially.
I mean, I think that it's right because I say the judge's reasonings on this were like a model of an explanation of sort of res judicata, as I always insist on pronouncing it, and issue estoppel, because they're not complicated. To be honest, these aren't complicated points. They do crop up a lot in litigation. But these things always turn on their facts. The underlying law is very simple. But I mentioned in that weirdo sheep case, we won the original trial, but then the losing defendant went off and told a trade journal his side of the story again, which was defamatory. But we had the issue there where we said, well, we're going to have to sue the journal now. And the trouble is, we couldn't put in the finding of that a judge had already ruled that my client was correct and these are all lies, because it said, well, it's different parties.
Mm-hmm.
So, we were going to have in the end, that settled as all defamation claims usually do, but not nearly all.
Another question about the juror from Hev. We did discuss this, but yes, I see what you did there. AH trying to get it reheard. Yeah, very, very good, very good. But yeah, no chance, no chance. We've heard it all before. But yeah, not going to happen. Interesting question here, though. Thank you, Kate, for the super chat. Is it possible that Johnny Depp could be in trouble in Australia as well? Amber's pretty good at passing the buck. Well, the point here is they're going off Kevin Murphy's statement, essentially. So probably not. I can't see a direct line of sight to JD on this in Australia. Because as I understand it, she was sort of spearheading it, but could be wrong. But
he was flying from some film shoot, was he? And just ran and got on the plane, and everybody else had organised it. So I mean, you never know, and this is always the danger of litigation, whether it's civil or criminal. The one thing lawyers hate is surprises. And can we just say, never ever say in a witness box, as I have had to go, actually, I haven't even told my own lawyer this, but it's like, oh, thank you for not mentioning this in the last 18 months that we were prepping for this trial.
Yeah. The petition I've put in the chat and should be in the description, and it's in practically every Johnny Depp video description that I've done. So, I mean, if you just Google Black Belt Barrister petition, you'll find it. It will come up fairly quickly. But yeah, we're up to almost 72,000. Like I say, I think we need an absolute minimum of 100,000, and more likely, 500,000 signatures to really get something moving on that. But who knows? Really, who knows? It's a case of make enough noise and see if you get somewhere. Al, you asked me to remind you of this.
Oh, yeah, I just thought people might find this interesting because you'd mentioned in the Popcorn Planet thing, which I've managed to see the first 6 minutes of it, so I'm looking forward to seeing that afterwards. But about the sort of the defence of, well, I was lying, but that doesn't really count and that doesn't show I'm dishonest. This is an interesting one. Now, UK viewers may remember a football goalkeeper called Bruce Gobelart. And this is interesting because, like I say, when we do this, we're talking a lot about that trial, but it highlights more general issues about appeals generally and things that hopefully are useful to people. Mm-hmm. So anyway, Bruce Gobelart got caught out in one of those sting operations where he was on video saying, "I will take bribes in exchange for throwing matches. I will let goals in," and this was all published in the press. And Bruce was obviously a bit annoyed about that. So he sued the newspaper. But his defence was fantastic because his defence was, yes, I took the bribes, but I didn't actually throw the matches. I just took the money and then just played normally. And he won in front of a jury. A jury went, oh, okay, fair enough. That's not what they said. They said he took money to throw matches and he didn't throw the matches. That actually went off to the Court of Appeal. And the Court of Appeal just went, that's even worse. It's like, it's like, so, and it's interesting because the last line of the judgment is basically send this back to the court for the jury to come to the correct decision. But eventually, it was going to go to. It didn't actually go to a retrial in the end because they saw the writing was on the wall and withdrew everything. But it was a very interesting defence because technically, it was true. The allegation was what the meaning. And this was, you see, before judges found what the meaning was of the article. It was up to the jury just to decide what the article meant. And they obviously interpreted the article as saying Bruce Gobelart took money and then threw matches. He just took the money and kept it. He didn't throw the matches. Therefore, technically he didn't do what they're accusing him of doing. But obviously you can see the Court of Appeal said, let's just apply a little bit of common sense here, please, ladies and gentlemen.
But using this argument here, and so in effect, he's saying, no, I didn't do that they accused me of. What I did was actually I was dishonest in the way that I did what they said that they're accusing me of. So it's worse. But using the same analogy, if, like, Australia is now looking at perjury charges because she lied during her guilty plea. She lied about the basis of her guilty plea in the bit that the UK judge was looking at the issues of credibility. And let me actually pull that up, because there's an interesting bit, and it's around the sort of 100 and something mark in the judgment. 116, if I'm memory serves.
You see, this is why I think our paragraph system, no disrespect to our American friends, this is why I think our paragraph system is better, because the idea is you just put 1 point in each per paragraph, and it just means you just have to give one number.
Yeah. And normally you know exactly where they are, and, you know, there's certain ones that just ring up, like, you know, 576, and we've talked about that earlier, but they stick in your mind for that reason. But yeah, this was this. So here, if we jump to the conclusion for this, judge says the offence to which Ms. Heard pleaded guilty involved knowingly making a false statement. Not a trivial offence, but, and this is I mean, it's right technically, but still, I think anyone would probably say it should affect her credibility, I would suggest. But anyway, but he says its nature is so far removed from the evidence that she gave in the trial that its relevance for her credibility is marginal. Now, this itself could be a standalone paradigm point to reopen the appeal, because if she's now convicted of perjury or perverting the course of justice, not just perjury, on the basis that all of this was based on yet more lies, so not only was she guilty of what she accepted, but she lied about it, and in doing so was perverting the course of justice, this would certainly cross the threshold of attacking her credibility. And on the basis that it's perverting the course of justice, which is as serious as it gets, it's like fraud of the worst kind. You know, you're defrauding the justice system in a sense, aren't you? So if this is defrauding the justice system of a proper decision, perverting the course of proper justice, this should shoot down her credibility. If that were decided by Australia, that should shoot down all the credibility. And so that means then everything, the rest of this judgment then should fall away, because her credibility falls away. That's the point, isn't it?
Yeah, I think so, because this more than any other case, and I think, and I like no disrespect to Nicol, because judges are entitled to sort of, look, there is. I'm not saying this has happened in this case, but there were some judges, Denning, for instance, who were famous for going, right, who do I think should win? I think you should win. Right? How do I write something that gets you winning? And there's that famous example where he starts off with a description of playing village cricket. And you read that opening paragraph about how for hundreds of years it's been part of British culture, that the lovely sound of leather on willow on the village green. Remember, this was a claim between a cricket club and a building developer or something. And it's like, I think we know who's going to win here. And there is this thing of, you know, it's quite strange, because pre sort of Human Rights Act, judges weren't technically obliged to give judgments, although they always did. They always gave at least some, some rationale for the decision. But now they pretty much have to do every point. And my one thing of quasi-judgment idea, I got roped into being an arbiter on something. Mm-hmm. And it was really difficult, because I had to address every single point in the evidence, because although under our Arbitration Act, you can get anybody to resolve a decision for you. Mm-hmm. You can say, like, we're not going to go to court. We're going to agree that this is... But then once you've done that, that is appealable within the court system. So there was a risk of a real judge looking at my decision. And it was really nightmarish, making sure I ticked every box and covered every point and explained every decision I made. But sometimes judges will come along and say, you know what, I think you should win. I'm here. It's what we call the sniff test. Some judges will go, and it boils back to this: 95% of cases try themselves. You just go, right, it's fairly clear who's the wrong and who's but sometimes we get that wrong. And that's when it becomes apparent that maybe people were rationalising after the fact. And there may have been, I'm not suggesting there was, but that sometimes happens in judgments where judges will basically rationalise after the fact. And it's only when something else comes to light that you sort of go back and go, well, hang on a minute, should they have done that? But it could have, the judge could have just said, do you know what? I saw everybody give evidence and I found these lot were more credible than the other lot. I prefer the evidence of. And that would have been an impossible decision to overturn. And that's why pretty much the Court of Appeal, well, it didn't even get to the appeal stage. It didn't get past the leave stage. They said, look, ultimately, whatever you think about this, a judge made a series of decisions about who he was willing to believe and what he was going to put on evidence, and that's purely a matter for him. Yeah. And they didn't even say they actually did address something that the trial judge didn't address. They said it matters not if Miss Heard herself is an abuser or she has. Well, they actually said embellished or exaggerated, which they don't like to say people lied, or she may have embellished or exaggerated. All the judge had to find was one incidence of something. Yeah. And that was enough to get it across the line.
Yeah, exactly.
As it happened, they found 12, and we're not going to interfere with that.
Yeah, and that's exactly the point. So, and now, again, because after the event, if something more it comes to light, then of course both of these courts did not have that information in the first place, so they could not have come to a different decision. But I mean, I find the skeleton argument for the appeal compelling, but ultimately the Court of Appeal obviously just wasn't going to look at it because it was ultimately questions of fact and everything else. And the thing is, they were questions, and this is the real point that I think a lot of people are upset about it for is. The real point is that a lot of the decisions were based on fact that couldn't really be decided properly without having her as a party to the case, and she wasn't, and that was the big thing.
Yeah, I mean, one thing that's going to come back and I think present problems for them with the American appeal is there's one thing where I think the judge says Amber Heard and her sister are independent witnesses. They don't have a dog in this fight. And it's like, well, they sort of do. But in some ways, actually, from a purely detached point, they don't. This was one person going against a newspaper, and somebody, I suppose, wasn't effectively an independent witness because they could have said it doesn't matter to her who wins or loses. She's got no interest in this. But the judge basically looked on it. If you have like a traffic accident, and you've got the two. One set of witnesses are your friends in your car. The other set of witnesses are the other guy's friends in his car. But then there's somebody who's just waiting at the bus stop. That's where courts go, they're an independent witness. And that's truly independent. Whereas somebody who effectively her own credibility was at stake here, arguably, they may have had an interest. They might not have had an interest in a financial sense, but they certainly had an interest in a reputational sense.
Yeah.
But that's going to come and bite them back in. That's why the American court, I think, will go, I'm sorry, your position very much was, I am not a party to this case. So you can't
yeah, exactly. And the other thing is the what some people have described as double standards with how they judged parties. And so, if Johnny Depp's staff worked for him, so clearly they were loyal and therefore not reliable. But we believe Amber's sister, even though there was a video that surfaced of her clearly wincing about having a fight or being beaten up with, or whatever it actually showed. So there's lots of questions. People have lots of questions. Shall we touch briefly on, because I put it in the thumbnail, briefly on the ACLU? I mean, there's opinion warning here, so not legal, but opinion warning here. I think, quite frankly, if some of Johnny Depp's money found its way to ACLU in whatever, for whatever purpose and whatever form that it came in, if that found its way to ACLU, I don't think it's fair that they're suing him for the costs of producing documents for their assistance in the op-ed, which has now been found by a jury to be defamatory. I think that's a bit harsh. Just putting it out there.
It's the rules, though, because, like I said, we were able to say when everybody was going, "Oh my gosh, the ACLU sued Johnny Depp for $86,000 and she awarded $38,000 or what's going on." We were able to say, we said this would happen.
We did call it. We did call it. Yeah.
But the rules are really straightforward.
Yeah.
And like I said on the last one, judges always knock your costs down a bit.
Oh, yeah.
So it was very much not a surprise to litigators. Whatever you might think about the rights or wrongs or the justice or the injustice, like I say, it's all this detachment. And it's like what we said before about who's a party and who's not a party. Mm-hmm. You're only a party if you are named as a party. So people might say, well, the ACLU should have been sued, or the ACLU should have, they're in. It doesn't matter. As a matter of law, they weren't a party. They were a third party, which I know it's confusing terminology. So why should they be put to the expense of photocopying documents that somebody else needs? Mm-hmm. That's the argument. And the courts go, no. If you'd have wanted to go against them for costs, make them a party. Of course, in America, it doesn't really matter anyway because you've got this American cost rule. The only thing with drawing the ACLU into it is you wouldn't have had to pay their cost of discovery because they would have had to pick their own tab up.
Well, that was the other argument, wasn't it? Because a lot of people have said, well, why didn't they drag ACLU in as a party? Well, for what you've just said, for one, Al, because there's the risk of the cost of discovery, and I mean the amount of I don't know if I can put it up very quickly, but if I can put
just
it up.
When you're doing that, there was a very interesting thing because like I said, I used to do like night lawyering, sort of and I still do pre-publication advice. I have now seen the pre-publication advice between the ACLU and the Washington Post, and it's very interesting in terms of what they thought might be problematic and what wasn't.
Yeah.
And like I said, I don't think the op-ed would have been actionable in the UK. But I think they got it slightly wrong in terms of their advice and what they went with. But they were very, very much considering. They did have one eye on we might get sued over this. So they were very cautious. And I know it sounds awful. I think they put themselves in a position where if we do get sued, we can throw her under a bus. But we'll be all right.
Yeah, pretty much. Because, I mean, as I said, for all the same reasons, it was about her. So they'd have won that argument hands down because it was about her. So, yeah. Amanda, if she is charged with something, what would she face with? Well, as far as I recall, it could carry 14 years, but I think they're unlikely to extradite her, frankly. But who knows? We'll have to wait and see, I suppose.
It's the sort of thing where if you were to go on holiday to Australia, you might be slightly concerned about it. It's like when people commit offences that, when they get lashed up in Spain, it's like, well, unless you're daft enough to come back here, you won't be hearing from us. Yeah.
And a lot of people, I don't know if I should say this on air, but anyway, I'll say it anyway. A lot of people escape territories to avoid debts. So a lot of people, let's say in the UK, go to Australia or vice versa because there's a 6-year limitation on recovery of debt, unless it's linked to a property, in which case it's 12. And that includes mortgage shortfalls. But yeah, a lot of people jump jurisdictions to evade debt.
And a lot of people come to a UK to make them to go bankrupt. Because in a lot of jurisdictions, bankruptcy isn't discharged until 12 years. In the UK, it's discharged after 12 months. So people will sort of go, I'm going to go on holiday to England, and while I'm here, I'm going to make myself bankrupt.
And that's just amazing, isn't it? It's just, and it's quite, it's fairly all-encompassing in the UK. There's very few things that it doesn't cover. Like criminal fines and child payments. What else? I think final divorce orders, things like that. I think they're not covered.
Yeah, all this stuff like when it's effectively secured creditors, money that's on trust. But the other thing here is what counts as an asset in bankruptcy. Mm-hmm. Interestingly, when they go after your asset, one thing that doesn't count as an asset is a defamation judgment award, because that's a personal thing to you. It's because it's compensatory. Same as PI awards.
It's to feelings and reputation, isn't it? But.
Compensation for purely financial loss actually ends up belonging to the trustee in bankruptcy, but compensation for physical or mental harm to yourself, you get to keep. But that was a big problem, like, insolvency shopping. As somebody pointed out, only an act, because the act that came in here, which basically makes bankruptcy really easy and relatively not long-lasting and not particularly consequential, said only in the UK could an act that makes like personal and corporate insolvency easier would be called the Enterprise Act. And that's literally what it is. But the rationale is, look, we all mess up. Why should you be penalised forever, especially for companies?
Yeah.
Because just get back on your feet as quickly as possible. And like I was going to say, some of your viewers may be worried about sort of debt and finance and things like that. And I'm not suggesting bankruptcy and insolvency is something to be taken lightly, but there are lots of alternatives, and maybe we should chat one day about IVAs and CVAs.
Yeah.
But the bankruptcy rules at the moment, post-COVID, especially for corporates, one of the things they've changed, they've said, I actually went to a seminar about this with the official receiver before, when they brought in, and it said, it will now be we will not now make a winding up order if there is a chance, if you can show that you can trade your way out of insolvency. And I said, what will be the test? What evidence will companies have to produce to show that they can trade their way out of insolvency? And the official receiver's rep just went, day after say, we reckon we can trade our way out of insolvency. Said we're not going to look at this very hard.
There's a very interesting question as to whether, whether Amber could arrive in London to file bankruptcy.
Yeah, I mean, the thing there is, it's right. Some countries have arrangements where they will enforce each other's legal judgments. So, for instance, in the UK, we're part of something called the Lugano Convention, which covers all the EU countries, all the EFTA countries, and a few others. And it's basically, if you get a judgment in any of those countries, they will enforce it in the other country. So if I get like a judgment here and somebody's got a property in France, I can claim the property in France. Interestingly, one case I was instructed in was trying to enforce a judgment in Iran. And I did the English side of it. Now, there's no automatic right in Iran to enforce an English judgment. And they actually have a separate case, but it's more of a summary judgment thing where it's, are you liable for this debt? So basically, we put in a statement saying, this is what happened. Like, somebody got sued in the county court. They lost. They went to appeal court. They got knocked back, technically on leave to appeal. Technically, they could have taken it to this, but they chose not to. Here's a copy of the orders. Here's what our procedure is, and here's the final judgment. We sent that off, and the Iranian court said, well, that looks, well, they probably say that looks kosher. But they said, well, yeah, prima facie, you owe this money. So what's your evidence against it? Oh, well, it's like not right. And they said, no, we're not going to go behind the facts. We're satisfied you had a fair hearing. You had a fair appeal. We're not going to look behind, but rather than just take the judgment on the face that they would in a convention country, they said, we will look behind that, but we won't revisit the case. All we need to be satisfied was that you had a fair trial. And they said, yeah, you've had a fair trial, pay them the money.
Yeah, so tough. That's fair enough. And it makes sense because, again, if you've got a competent jurisdiction, then it should stand by the judgment. I mean, in fact, my master's thesis was on the inadequacy of the laws and the rules regarding domain name, international domain name disputes. In other words, people have an argument about a domain name. There's an arbitration process, either with Nominet or UDRP, and essentially you have what is technically an arbitration. So you get either a single panelist or a joint panelist decide on the dispute, and they decide to transfer a domain name one way, one direction or the other. The problem with that is at any stage, either during or even after the decision, any of the parties can raise a dispute in their local court. So as you say, it could be Iran or wherever. And if that happens, then the decision just set aside. And it's got to be heard in the local court. So if it were me, I'd have to trek off to Iran to dispute it. So I literally wrote a master's thesis on why that was a bit nonsense. And I can say I can stand by that decision because I got a distinction from my master's. So I think it's a well-rounded opinion, quite frankly. I think it's bonkers because what is the point in the arbitration process when you've got this rule that says, but if someone files a claim in their local court, they can circumvent and circumnavigate the entire process. Outrageous. But anyway, please do go. Lots of questions about the petition. It's in the description. I've put it in the chat. It's on every video that I've done Amber and Johnny discussions on, or just Google it and you'll find it. Sorry, Al.
No, just to say, because again, this case it's a great jumping off point for chatting about things that might actually be relevant to people. One thing you can do in any contract is you can do like a jurisdiction clause. And you'll see this if you ever read the small print in any of your contracts. It'll say something like, it'll say which laws we're going to use and which court has jurisdiction. A very common one is this contract is subject to the laws of England and Wales, and the English courts will have sole jurisdiction. Due to a bit of a weird thing, once we had a case where we were actually arguing in an English court, but under French law, because they said this contract is subject to French law, but the English courts will have sole jurisdiction. And that was because it was between French people who worked and lived in the UK. But the court was going, well, hang on a minute, because then you have to get expert witnesses in to explain French law to the judge, and the judge was going, well, I know you're allowed to do this, but don't ever do it again. You can actually put in there, and you get this a lot, we call arbitration clauses, where you can say, in the event of any dispute, you don't have a right to go to court. This is how we're going to sort it out. And then if somebody sues you, when you get the first, what we call the acknowledgement of service form, you can tick admit the claim, or part of the claim, deny the claim, but you can also tick the court has no jurisdiction.
No jurisdiction to hear the claim.
Say, here's a copy of the contract. It says they're not allowed to sue. We've got to do it by arbitration.
Yeah. And there are limits, but there's a £5,000 figure that features and various other things, and there's certain things you can and can't sort of contract out of with arbitration. So if you're going for arbitration, there are certain bits of it that are mandatory and you cannot get out of. But yeah, ultimately you could say, you could say your law is based on the law of England and Wales, but your seat of arbitration is Switzerland or whatever. So it's got to go to be heard in arbitration in Switzerland.
And you could literally say something like, in the event of any dispute, we'll let Barry down the pub sort it out, and that would be binding. And as long as Barry said you win or you win, you could then go to the court and say I want to appeal, and they say, well, no, you agreed to leave it up to Barry in the pub. And seriously, that actually, a lot of cases are sorted by arbitration, either informally, because you've got your Beth Dane, and there's a Chinese court in Manchester that looks at Chinese people. The oil industry do a lot of stuff by arbitration. They've got this fantastic place out in the UAE where like retired judges make a nice little addition to their pension sitting there. I mean, arbitration has a lot of positives because it tends to be cheaper, tends to be quicker. The arbitrators tend to be experts in the field. Like all the judges who sit in the oil courts know a lot about the oil industry, so you don't need expert witnesses. I'm involved with something called the Court of Arbitration for the Arts in The Hague. But effectively, that's just something that resolves art disputes. And another reason is, these courts they're not really courts, but these things, they can do things that regular courts can't do. Like they don't just have to do money. They can say, well, okay, here's the deal. Next contract you get, you give him the work to do that or something like that. But also they're confidential. Unlike real courts, everything is confidential. And especially in the art world, people don't want people knowing what their art is or where it's come from or how much it's worth.
And that goes for mediation as well. So one of the first things I did was to become a mediator. And in fact, even when I was training, somebody said to me, "Yeah, you'll never become a mediator. It's too competitive and whatever." But I got the ticket like within the first year or something. But yeah, it's all confidential. So a lot of people do mediation for the same purpose. Just coming quickly, carry a bag. If that, I know that's not your real name, but there we go. Dispute for a domain name after 20 years. So the funny thing with this is it's not the age of the name that really counts. You've got to go back to, and there's such a lot of case law on this. And again, it depends whether you're talking about the dispute in the arbitration process or the dispute in court. And then you come under copyright and trademark and everything else. The starting point, the jumping off point is you look back to the beginning and was it registered in bad faith? For argument's sake, if I were to register a domain name XYZ Supermarket Sucks .com, and everything on that website is to say that how rubbish that supermarket is, nothing wrong with that. It's, you know, it's been held that that's fine. You know, I can talk about it because I'm expressing opinions and all the rest of it. However, on the other hand, if I were to do, you know, similar to Gucci.com or whatever, that's clearly to try to attract people that are looking for Gucci, but they'll buy mine instead because mine's a cheaper version or whatever, something like that. That would clearly be, you know, on registration would be bad faith. So you look back to the origin in a lot of these cases, and in almost every case you can look back and see whether it was registered in bad faith or not. And so you can cut to the chase a lot in these cases. But then there's also the principle of trademarks, and if you don't use it, you lose it. Not necessarily registering it. So, I mean, BlackBeltBarrister is a registered trademark, by the way. But even if it wasn't, it wouldn't really matter, because anyone else popping up to say, "Hey, I've used that before," well, that might be the case, but I got 9 million views last month, and so, you know, it's quite a prominent name. I humbly suggest. So the point I make is that the challenges to the trademark, even if it wasn't registered, would fail because of the popularity, the amount of times that it pops up. But it's registered nonetheless. But then if I were to go and register, I don't know, let's pick someone. Let's pick Tesco, and let's say Tesco is a supermarket for anyone that doesn't know. But if I were to say, you know, Tesco greenhouse or something, you know, and come up with a specific product, but I've stuck on the Tesco name before the name, clearly that's in bad faith because it would breach their trademark. So there's all sorts of different things. So it really depends on the specifics as to how it was registered in the first place, why it was registered, whether it's been used, how long it's been used, and again, use it or lose it. So if you've got it, if you've registered a great name but never used it, I've registered some names before, like thinklawyer.com. I owned at one point, right? Because I registered loads of different names with the idea of using them and didn't. I've even registered BlackBeltBarrister.com as you know, in addition to barrister. for the joke side, that I'm literally going to, when I get around to it, I'm going to start selling coffee, and the tagline on the front is going to be me in a wig and gown selling coffee. So, you know, the double entendre joke and all the anyway. So, I digress. The point is, if you use the name, there's sort of automatic rights in the use of it and things like that. And interestingly enough, I'll stop talking in a minute because this was literally my master's subject. But interestingly enough, even if you win a dispute to stop someone else using a certain name, that doesn't necessarily mean you can use it, because if they've built up goodwill in the name, but a lot of that was derived from the goodwill that you've generated. So they've built new goodwill, but they only got that because of your original goodwill, then you can stop them using a particular name, but it doesn't mean you can use it because they've built up goodwill, separate goodwill, that you're not entitled to because you didn't build it up. So it's really complicated. IP is a really complicated area, but that's partly why I love it. But and I suppose art's the same, isn't it, Al?
Well, because I've got quite a lot of like weird IP stories, but the name thing happens a lot with bands. When bands break it into another territory, and it turns out that's why the Mission, you know, the West Yorkshire goth band in the US was the Mission UK, and you know, there's various bands called Africa, and Toto Coelho, the 1980s girl band, they had to change their name when they went to America in case people got them mixed up with Toto, the, you know, proper band. But just as an aside about trademarks, this is a little bit of local trivia. When I moved to Cornwall, just so I could join in conversations in pubs, one of the first things I bought was the Encyclopedia of Tractors, which actually is fascinating. So when the Ukraine thing started and people were going like, the tractors towing tanks, and all my military friends are going, technically that's not a tank. I was able to say, technically that's not a tractor. But just as an aside, you will see tractors that say Ford on them. And there's a company called Ford that makes tractors. That is not Ford, the motor company. That is a different company because they were making tractors first. However, Ford do make tractors, but they have to call their tractors Fordsons because the other company has said, sorry, you might build cars. We were building tractors before you were. Our name is the one that people associate with tractors. So you can go off and whistle, Mr. Make some cars.
Yeah.
So there you go. If you ever see that, if you ever see a Fordson and a Ford, the Fordson is the car manufacturer and the Ford is a completely independent company. And Ford counties, by the way, are very collectible.
Okay. And another question here. Yeah, this was this is an interesting point for back on bankruptcy. I'm not a bankruptcy lawyer, but Al sounds like he has some experience, but doesn't one have to prove residency before filing bankruptcy in another jurisdiction?
Or at least a connection with the country. And this is something that people did try and challenge. So it was very easy for Brexit. It was very, very easy for EU citizens because they'd say, I just pop over there and, it's no difference between filing for bankruptcy in London if you live in Manchester. It's like, well, I live in Paris, but I'm going to file for bankruptcy in the UK. But yeah, you do have to sort of show at least a connection or a recipe. But this was happening a lot with a lot of Irish people coming over because in Ireland it was 12 years as well. And because of the weird way we've got the common free movement area that's nothing to do with the EU, you've got a lot of Irish people and Irish companies declaring bankruptcy and insolvency here. But yeah, I mean, and a lot of the time it's will people even notice? You come over here, you put the petition out, you put the thing in the local paper saying any creditors. They will sometimes say, well, hang on a minute, you are deliberately trying to avoid all your creditors back home and things. So you should at least contact them because you've got to give a list of people that might be supporting creditors and petitioning creditors and all this sort of nonsense. But yeah, you do have to show that connection. But part of the thing is, it was one of these forum shopping things where people probably were abusing it. But having said that, they said, well, the law allows them to do this. So just because they're taking advantage of it, can't really stop them.
No, exactly. We cannot let this go. Let me just bring it up on screen. And the floof by Al, I'm sure you're familiar with the floof. The floof is the black belt floof. Melt hearts to your heart's content. Link in the description. She now has 724 subscribers, and I think this morning I released a video. I was working from about 5:30 a.m. this morning, which you can see from me. I released this 7 hours ago, and she was chewing this all morning. So this has now been viewed. Literally her chewing her chew. This was really nice. This was from Eleanor. Eleanor gave us a super chat for buying some chews, and so I literally filmed going to buy those chews. I'm going to play it so it gets through the advert, but that was very very kind. Right, I can skip the advert now. So yeah, literally we literally went to the shop and bought some shoes for her. So that was from Eleanor Stansby. I think this was because at the outset of one of my videos, I knew there was going to be noise in the background, so I apologized in the beginning by saying there's going to be noise in the background because she's sitting there chewing something. So Eleanor said, go and buy us some chews. So we did. So this is her coming to buy some chews. Anyway, we digress. It's nothing to do with law, but everyone loves to see a floof now and again, don't they? But
I've just sent you some pictures of my dear departed floof, who's shuffled off this mortal coil a little while ago. She was more of an accomplice than a dog, but we had some adventures. But yes,
yeah. Do you want to bring on screen or?
I sent them to you. I don't know how to do all this.
No, I can do that if you want me. Yeah, if you want me to bring on the screen, I can.
This is my floof. This was Staffy.
Oh.
That's in her dotage when she was getting on a little bit.
Yeah.
And then there's another picture where she was like.
Another one. Let me open that one in preview.
Only good thing. I've got like 4,000 pictures of her, and that's the only good one.
Oh, how adorable! Alan's
very cool.
Late floof, everybody. How sweet. I very, very nearly went with this breed, but we chose a non-molting variety.
Oh God! She's a Belgian Shepherd, and seriously, I would brush her, and there'd be enough fur net left over to knit another dog. It's like, where is this coming from?
Yeah, crazy. Oh, I'm sorry, carrier bag. But yeah, love living Peach Dream, if that is your real name. Give a like up for the floof. Yeah, if not, if not like for the channel and the lore element, give a like for the floof. Yeah, you see, this brings everybody together. You see, this is why the floof's got her channel. And let's go back. Let's showcase Al's floof once more. We can dedicate a bit of time to Al's floof. I'm sure.
17 years, not a bad innings for a Belgian Shepherd.
Not at all. Not at all.
Shall I say that's a later on where she was getting a bit old, having to carry her over stiles and everything.
Yeah. How sweet. I will save those.
Oh, thank you.
I will save those photos. Yeah. So yeah, the the black belt floof's got her channel in the chat, everybody.
I'll tell you what though, the sassy, she heard a lot of jury speeches. Because she's like, right, okay, what do you think? Because I used to watch it all the time, and I would be walking out. We used to go on these long walks, and we'd be just running ideas by her.
Yeah.
What do you think? Do you think I have a good point on the Aristotle? Like she'd be like, "What, I'm a dog."
Ooh, that's a celebrity friend of mine. I have to say, I'll have to politely decline it because I will ring back later. But also, whilst we're on the subject of shameless plugging, if it loads up, here we go. Back to Safari. I've taken to putting my opinions over on Black Belt Secrets, everybody, because I try not to put opinions on my Black Belt Barrister channel. I do now and again. Links in the description if you feel like heading over to subscribe. Because, well, there's a few things I've given opinions about on here. Started out with martial arts 9 years ago. And I mean, this one here, this was literally a video to help someone with back pain, and it's now got nearly 4 million views. So that's my kind of hero video, if you like. But yeah, feel free to head over there and get some of my real opinions. That's my sort of alter ego, which I'm beginning to think Al's got the same alter ego, but but there we go. Anyway, we digress. So where were we? How long we are? We're just coming up to 2 hours. I don't know how you are for time, Al, but we normally say 2 hours. We'll do a cut-off point so that we're not fatiguing everybody. But yeah, of course, I agree that Alan is well spoken and understood. And please put the
actually that's something to mention at some stage. But we saw about like barrister secrets and how the law works in practice. Yeah. When I was in London, my USP was I would actually dial up the Yorkshire accent a little bit, especially for jurors, because the West Riding accent, which is my home accent, is considered to be very credible, which is why they use it a lot in adverts. And I would, because my USP was, I'm straight talking northerner who doesn't like, now, Your Honour, we could get bogged down with all this legal mumbo jumbo nonsense. You go like, what, you mean like the rules of law and evidence? Well, yeah, but when I moved to Cornwall, I had to posh up a bit to be sort of proper London counsel. What you're hearing now is pretty much my natural voice. But it's my natural down here voice. When I go back to London, after about 3 days back, I sound like I'm in the Sweeney. But because I just spent so long there. Yeah. But yeah, accents are interesting. I once got an instruction in a case where I was being led by somebody who was fantastically brilliant on the point at hand. But there was a worry that the jury in this particular area would find her very upper-class, cut-glass accent a little bit off-putting. So it was like, she'll do all the work, but can you do all the addressing the jury? Because we just think your accent won't be as alienating for a jury in this area.
Yeah. No, I can absolutely see that being valuable. Melanie, yeah, we did talk about all of this. I don't think we actually used the term. I think we probably did use the term setting aside at some point earlier on, didn't we, Al? But set aside essentially just means it's no longer in force. That's probably as clearly as we can put it, isn't it? So if you apply to so if you get a judgment, then it's the court has ordered this, whether it's by a jury or by a judge, it matters not. If it's an order of the court has said you must do this, pay this, do that, not do that, whatever. If it's set aside, it means actually no, just don't worry about it for a minute. Ignore it for now. That's essentially what it means. That's what a set aside means. So, and we did look at that team looking to set aside the verdict. I think it's safe to say we think there's very little chance of anything going anywhere, bar a couple of technical points, but still not really going anywhere. Anything else on that? I think that's it, really, isn't it, Al?
Yeah, I think so. I mean, set aside is just a term where it effectively means it's as if this never happened. It's rather than overturning or overruling. So it's a technical distinction. But you do this a lot where you'll go, like, I'd like to set aside a default judgment, or I'd like to set aside this finding. It just basically means it's not an appeal level thing. Yeah. It's not been overturned or overruled. It's just been, actually, we've decided that never happened.
Yeah, exactly. It's not an appeal. It's just let's just put it to one side as though it didn't happen. This is not necessarily the case either. But put aside so she won't pay interest. Well, when the court makes certain orders, one of them is going to be, well, if you're going to appeal, you need to show, well, she's been ordered a bond, hasn't she? So if she wants to go ahead with appeal, she's got to put up the bond. No, I'm familiar with that, Tam, BBB in Canada's with the Better Business Bureau, because what was it now? There was I was on something about 2 or 3 months ago when I had to look into it and correspond with them, and it took a long time to come back and say there's nothing we can do about it. I thought, well, that's useful. Took a long time to come back and say nothing you can do about it, but never mind. Sorry for you to join us late, Donna. Actually, almost wrapping up, but for 24 hours you can watch it start to finish, and then it goes to members only. The members join button is just below the video. Actually, I'm on that, so it's over there. It's down there. And thank you for the kind comments, Sophia. We have a great time, don't we, Al? So hopefully everyone does. We've been consistently over 2,000, touching 2,500 from most of the live chat. We just rolled over 2 hours. I think that's probably as good a time as any to say let's get to our evening. But any last questions? Any final burning questions that you absolutely wanted to ask, but you've just sort of hung out with, or any last super chats that you wanted to get in and have been thinking about, but didn't quite do that? 2 or 3 minutes, I think we can muster, and then there's an interesting one here, because this is there is a difference. Always disputing if that is your real name, which I don't think it is. Is there a difference between striking out and setting aside? Yes, there is, because setting aside relates to a decision, a judgment, whereas striking out is in reference to either a statement of case or a witness statement or a piece of evidence, usually a statement of case or evidence. In fact, interesting point, actually, there was... you remember the bit in where Amber's team objected to their own, the answer to their own question, because it was hearsay. What he really ought to have done, and I'll probably have to clip this for another video, but what he ought to have done there was to motion to strike after the answer to the question. So the hearsay bit that was separate and not an answer to the question that he actually objected to, he should have had a motion to strike after that point. But even then, it's kind of a bit pointless, because the technicality is, he says to the judge, strike that bit from the evidential record, and then the judge will turn to the jury and say, now you must pretend that you never heard that bit, because that bit's not evidence, because that's been stricken from the record. But of course they've heard it, and we're all human. It's a bit like it's like a common complaint with the magistrates' courts in England and Wales, when the magistrate is hearing a criminal case and they hear inadmissible evidence, and then someone says, "Oh no, that was inadmissible," and the magistrate says, "I'll just pretend I didn't hear it." But the inadmissible bit of evidence is where a defendant was found with the weapon in their pocket or something, and whatever, and maybe the only reason that it was inadmissible was because the search was illegal or whatever. I mean, that's a bad example, because that wouldn't count, because even if the search was illegal, they could still say they found the weapon and so on and so on. But anyway, technicality. But you get the point. Magistrate is, they'll say, "I'll pretend I didn't hear that." So without that bit of evidence, I've heard everything else, and I find them guilty. Striking out is stricken from the record of evidence. So if it's like a statement of case, it can be struck out for various reasons, usually not complying with the rules, or, as Al said earlier, using the wrong font.
Yeah.
I think I even found the guidance. I don't know if you spotted it come up on screen, Al, but I've closed it now. But I literally, I found the guidance. Is it that one?
Yeah, but like I say, they've been taking it really seriously. And just to say, with the strikeout thing as well, it's one of these things where we've got words in the law that mean different things in different contexts. So as Dan was just saying, you can strike out either a particular, like a claim or part of a defence, or even a case as a whole. The difference between strike out and setting aside in that situation is, setting aside is, we have made a decision, but now we're going to imagine it was never made. So you set aside a judgment. It's like we found in somebody's favour, but now this isn't an appeal. We're just going to say, actually, that judgment doesn't stand. Striking out is, and this happens a lot in defamation, where we'll go, actually, half of that claim isn't arguable as a matter of law. Judge, can you strike it out? So you don't even get a decision on it, because the judge says, I'm not even going to allow that to go forward. And it's quite often a penalty as well for if you disobey a court order. They'll say, I'm going to strike out that part of the evidence. I'm going to strike out your defence. You can't defend this. You missed a deadline or something. So.
Yeah, and I've won cases before now in their entirety with full costs and penalties and all sorts, because they didn't comply with the filing for the deadline for evidence. In fact, it was worse than that, because long story short, really, but it's an interesting one. But they didn't file evidence at all, it seems, and despite saying that they did. But because they didn't file evidence, the defense was struck out. So there's a distinction between the defense statement, the defense case statement, or the defense, the civil defense, and the evidence that underpins it. So one of the sanctions for not filing the evidence that backs up your defense. So your defense is, I'm not liable because of these reasons. But that's not the evidence. Your statement of defense is not your evidence. The evidence comes later. But because they didn't provide the evidence, we said, well, we want the defense struck out because they didn't provide the evidence on time or at all. And so the judge said, actually, the judge tested it first, and this is why I got all my costs and everything else, on with penalties and so forth, because they said to the judge, we emailed it to the court 3 weeks ago, which, I mean, we didn't accept, because if they did that, we'd have all seen it. The court would have had it and so on and whatever. But the judge tested it and said, okay, forward me the email that you sent 3 weeks ago. And I thought, ouch, and I thought, we're going to sit here for a few minutes while they're embarrassed about trying to find this email. Of course, they hadn't sent the email. They couldn't find it. And so that didn't go down well. That was probably the worst way that could go down. So yeah, that's that. A few questions to wrap up, I think. A barrister is a UK lawyer. Yes. What one might say with a senior half of the profession, although some people would frown at us for saying that, but there we go. We're the equivalent of what you would call a trial lawyer, I suppose, which I think in the US and Canada is usually when you've got more experience, but I think take that as you will. We're trial lawyers from day one. What else I was going to look at? I favorited one that I was going to look at a minute ago. Yeah, this one here is quite relevant. I did a brief video on the strike. No, I'm not, because it doesn't affect me. Because it doesn't affect me, it's not that I don't care. I very much care. But I did a video about it in support of my colleagues that are on strike, because legal aid could see you doing a case that you end up hanging around court all day for £91, not including, not adding on any fees for travel and everything else, and out of which comes obviously tax, your chambers fees, your travel and everything else. So actually some barristers end up going to court and coming home with less money than they left the house with in the morning, and that's just not right. Whereas I do mostly commercial work, and a commercial lawyer, even with a few years experience, is you're looking at £300 an hour, not £91 a day for not even covering your expenses. So no, I'm not going out on strike, but I did the video, and I'll probably do more videos in support. But thank you for bringing that up, because it is an important issue. It's one of those, isn't it, where and unless and until you're affected by it, a lot of people don't care about it. But it's the sad truth and the sad reality. But until someone's caught up in the system and then say, well, hang on a minute, this is terrible. This is a really bad system. It's like, well, hey, yeah, that's what we were saying. That's what we've been saying for years. Like, some people at the moment are saying, well, there was one I was quite offended, actually. There was a journalist interviewing a QC the other day and said, quote, "No one's crying for barristers." And I thought, no one's asking you to cry for the barrister. What we're saying is barristers are leaving the criminal bar because of the pitiful rates of pay on legal aid. And so there are literally trials being cancelled. There's upwards of 400 and 500 trials being cancelled because there is not a barrister to prosecute or defend it, because the rates of pay on legal aid are so low. Like I said, you could do an all-day trial or whatever, or a list for a few £100 for the entire day, whereas out of which comes your travel, your chambers expenses, your chambers rent. And then someone said in the comments to that video, I'm on a bit of a high horse at the minute on behalf of my colleagues, but so someone in the comments to that video said, why don't other barristers help? And I thought, what an odd thing to say. Well, for one, why should they? Do do the more long-term staff at a supermarket pay for the junior staff supermarket top up their wages? No, that's not how it works. But not only should they not have to do that, they do that. That's exactly what happens. That's exactly what happens, because pupils, like trainee barristers, have a minimum award which is set by our regulator, so they can't do the training unless they have that minimum award. But if they don't earn the minimum award, the rest of the barristers in chambers contribute to pay that new barrister up to the minimum amount. So they actually do that. So I took offence to that. I think that was wrong. But anyway, that's my rant over. A more long-winded answer than probably you expected.
As we say in court a lot, I fully adopt my learned friend's submissions, which normally is a very lazy way of not actually doing anything yourself. But in this case, it is sort of genuinely adopting what Dan just said.
Yeah, and actually, very often it is often the best way of saying what he or she said, but reiterating, and it's a bit like in your defense. Paragraph 9 is repeated because the same reasons apply. There's no need to say it all again, but the same reasons apply. So but that's that really.
I know
Go on.
So I know people like Tales from the Bar, so I don't know if this is a good one to end on.
Go for
where
it.
We're saying about repeating things. I was once involved in a five-hander. When we say five-hander, that means there's like 5 defence barristers. Five-hander affray. It was some old gangster thing and kicked off in a restaurant, and it was brilliant. And we're all running the same defence effectively, which is the other side started it. It's all an overreaction. They favoured somebody, so we all stand up and make exactly the same speech. And a chap from our chambers, really it was a slightly eccentric guy, but really, really good, funny. He just stands up and he just goes, "Ladies and gentlemen of the jury, I feel like Joan Collins' latest husband. I know what I'm supposed to do. I just can't think of a way of making it interesting for you." And just sat down. That's a great jury speech.
Yeah, I can't really top that. I had an example, but it's nowhere as good as that. But so we'll leave it on that one. But anyway, no, Al, thank you. It's been a pleasure. To the 2,500 of you that have been watching, thank you all for watching. Thank you if you're watching the replay as well. Thank you for watching that. That will be up for 24 hours or so, at which point it goes members only, as a privilege to those that do join and make a small contribution to the channel as a channel member. And in a week or so's time, I'm coming down your way, Al. We are going to sit and have that drink. So we may be doing this one next week. We might be doing this one face to face, Al.
Yes. Yeah, I'll find somewhere nice. Find one of my business clients' sort of nice bars or hotels or something like that. Although if they then come over and start talking shop, I am just walking out there. Oh, by the way, Al, what about that case? Oh, bye.
Yeah, sounds good. Look, it's been a pleasure. Everybody, thank you for watching. Thank you for staying with us. Thank you for your questions, your super chats, your interest in the law generally. We find it a great joy. Please do smash that like button on the way out. And please do watch more. Go subscribe to the Floof. Subscribe to my Black Belt Secrets for more of my insights. There's a personal video on there